Faith.com, Alexa, TuneIn, iHeart, and at radio.com.
The fighting spirit of the Marine Corps is born of battles won. Battles won within, over enemies of fear, enemies of doubt. It's who we are. It's what we do. It's a promise made to you for more than 2 centuries. A promise of the Marines.
Ask an Attorney is sponsored by the law offices of Joe Pippen. Learn more at attypip.com.
Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open right after Thanksgiving. We're open early this 8 o'clock on a Saturday morning. And if something has come up, from last week to this week, or maybe just something is out there bothering you, give me a call. If you have a legal question of any type, all you have to do is to dial the toll-free number, which is 877-943-9673. And yes, you are listening to a live show. It's right after Thanksgiving 2020. In studio today just to answer your legal questions, your legal problems. If you have a legal question, you have a toll-free number, 877-943-9673. That's 877-943-9673. One of the more interesting questions I had this week was a question about splitting ashes from cremation. And the funeral home had given the client that came in this form to find out, giving someone the power, like a power of attorney, to split the ashes. And there's no statute in Florida that I'm aware of, and I talked to a couple of other attorneys just to verify I was correct. There's no power of attorney that's void after death, even to deal with body remains. So basically, we decided that the only way that was going to work was to put the instructions of that into the will and let the personal representative who's appointed as administrator of the will take those actions. I might talk a little bit about that more during the show. Let's go to Alan in Jacksonville.
Hello.
Hey, Alan.
Hey, I have a question. About 15 years ago, I had a trust done. And then about 2 years ago, as part of the asset protection deal, it included a trust. And I kind of forgot about the first one. So I essentially have 2 trusts. So how would that work? Does the second trust... and I had to take that. Yeah,
a person can have multiple trusts. That's no problem. Okay. It might be that there are different types of trust. You might have a regular revocable trust, which most people have, and you might have. Yeah, go ahead.
Yeah, they were both the same kind of trust.
Or were they revocable?
Yes.
Well, a trust is only as good as to what you put in it, really. So you have to retitle assets to the name of the trust. So you could have one trust, Allen Trust, 2010, and you could have another trust, Allen Trust 2015. It's how you title those assets into the trust that matters. So the trust only controls what you've placed inside the trust.
I guess a part of my question is that if they're not the same, would there ever be a conflict, something that I would have to undo now?
No, unless you have a particular purpose for having multiple trusts, I would consolidate everything into one trust. So everything's going to be under your name and under one date of trust.
So it might be a good idea to just, I don't know, can you invalidate a trust?
Yeah, you can make you make a trust an empty bucket. There's nothing in it, then the trust doesn't control anything. So you can have everything titled in just the one trust.
I got it. Okay, that's very helpful. Thank you very much.
All right, thank you. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. If I can help you in any way, doesn't even have to be a legal question, just a problem you're going through. Be more than glad to try to help you. You have a toll-free number, which is 877-943-9673. We're broadcasting today on multiple stations. We're broadcasting out of the Tampa station today. Salem Communications, our flagship station. They house 570, 910, 860, 930. Some of those have FM components as well. You're being heard all over the state of Florida. We have a station in Jacksonville, WBOB, carrying the show. We have a station in Clearwater, WTAN. We have several stations in Sun City Center, community stations. 96.3 FM and 100.1 FM. We have 90.3 FM coming out of Haines City, Florida, Landmark Voice of Faith station owned by Landmark Baptist Church. We have multiple stations carrying the program Ask an Attorney, all about Florida law. No matter where you're listening, you have a toll-free number, one toll-free number for all those stations, 877-943-9673. Phone lines are open. Let's go to Al in Lakeland.
Yes, sir. Thank you very much. Am I coming in?
You're coming in loud and clear, sir. What can I do for you?
Okay, thank you for taking my call. I appreciate it so much. I have a couple of questions here. My wife is getting a settlement from a personal injury here in Florida, and I'm wondering, is there a tax that she has to pay on a settlement?
No, sir. No, personal injury settlement is not taxable.
Okay, thank you so much for that. To give some money for your children out of that, perhaps adult children, what is the limit that you can give them per year?
$15,000 per year.
$15,000 per person?
Per person per year.
Okay.
So having said that, you could give $15,000 this month. You could do it again in January.
Right.
And that's $15,000 from you and $15,000 from her. So the money could be put into a joint account. You could give up to $30,000, $15,000 each to each child each year.
All right. I appreciate that. Since we're senior citizens, just a hypothetical situation, if one of us or both of us should pass away, or be not necessarily pass away, but if we're in a nursing home, we have to go to a nursing home for one reason or another, what about the assets there that we would have from the settlement or income that we have had saved? What would a nursing home be able to take?
Well, I have a full-time, maybe you don't know, I have a full-time Medicaid attorney, VA attorney, and what we do is we orchestrate moving assets around to make them non-countable so you can maximize what you can keep and maximize what you can get in the way of government benefits. Everything is authorized by statute and everything is approved by the Department of Children and Family once we finish. So it's, everything's above the table. You can move assets around and make them non-countable. So we often do that for clients. We can move cash, like from a personal injury settlement, into a personal service contract to make it non-countable so it doesn't count against you. Your homestead is non-countable. A community spouse can have $128,000 or so, somewhere right around there, plus a home, plus a car. And you can move other assets to make them non-countable. It's very important in that process to have a current durable power of attorney, giving someone the power to do things for you, particularly if you're in a nursing home. The person has a power of attorney to be able to do things for you. So, we give a free consult. Be glad to talk to you privately about this and look at what you have and how it might be moved around to protect it. But that's basically one of the things we do. So.
Well, I appreciate that very much. I'm taking notes.
Al, I do have an office in Lakeland. We have 15 offices around Florida. One of those is in Lakeland. I go to it every week. So.
Oh, great. I appreciate that very much. I wasn't aware of that. And thank you. And my last question, again, thank you for your time. I really appreciate so much your insight, your expertise. Banks or credit unions, we're not sure what to do. We have a savings account and a small other account in a bank here. We're not quite sure as to what we should do as far as a bank or credit union to put this in, the money. I know we can't put it in.
Yeah. Well, if I were meeting with you in Lakeland, I'd give you the name of several choices of possible people that to manage that for you or invest it for you.
All right.
Or you could just call me and I could give you some names.
All right, that sounds great. So
right.
I can call you at your...
Yeah, I'll just give you the 800 number, 1-800-226 1-800-226-3529.
226-3259. All right. Well, thank you so much, sir. You've been a great help. I appreciate it, and blessings to you. And,
it's 3529. I want to make sure you got the number right there.
32, yes, 800-226-3259.
No, 3529.
35, sorry. 35.
Yeah.
29, okay.
All right, Al.
Okay, thank you again so much, sir.
All right, thank you.
Have a great rest of the day.
Thank you.
Bye.
Let's go to Ron in Jacksonville. Ron, are you there?
Let me turn my radio on. Yeah, can you hear me?
Yes, sir.
Hello, I'm on Bluetooth. Can you hear me?
I can hear you. You're a little weak, but go right ahead.
Oh, okay, yes. We're looking at having a revocable trust set up. And question, we've got rental property and our personal property. What kind of charges are incurred? Do we have to pay doc stamps and all that when we transfer it into the trust?
No, sir. There's a quitclaim deed. If I were doing this for you, and I do have offices in Jacksonville, if I was doing this for you, I would do a quitclaim deed of each of those properties from you to your trust.
Okay.
The fee to record those deeds right now is like $19.20. There's no other tax or implication. You and the trust are the same entity. The deed doesn't necessarily have to be recorded now because there's not a change of ownership, so it could be in your trust but not a public record. But if we were to record it, then charges are like $19.20, so it's no big thing to
okay.
for the county.
Yeah, okay. Second question. Now, if we have a line of credit set up on those, and they're in our personal name, how does that affect? Sometimes they have a due on sale clause type deal going.
Well, this is not a due on sale, though. It's not a transfer to a different entity.
Oh.
So it's just from you to you as trustee of your own trust. So there's no due on sale clause implication at all with the trust. A self trust like this one we're talking about.
Yeah, right. Okay. One other question. I have a solo 401k set up now, and I have one piece of property that I purchased through that. Should that stay by itself, or can that be pulled into the trust as well?
No, the trust, that's a 401k that has a named beneficiary. So that would be outside.
Exactly.
That would be outside the trust and would also avoid probate. So there's no reason to put that in the trust unless you have a special reason that you want to control the money when it comes out of the retirement account.
Oh, okay. All right, so that would stay outside the trust. Okay, that's all I needed. Very good. You're very, very helpful.
Thank you. Our office is in Jacksonville, in the Ponte Vedra area. Just so you know.
Okay.
All right.
Very good.
All right. Thank you. Let's give out the numbers. Phone lines are open at 877-943-9673. That's 877-943-9673. Phone lines are open. Be glad to take your call. Be glad to help you in any way I possibly can. Let's go to Bill in Apollo Beach. Bill, are you there?
I certainly am. Thank you. What a beautiful day.
It is. What can I do for you?
My wife was injured on the job a month and a half ago, broke her arm. No problem with her employer, no problem with the workman's comp carrier. they're taking care of it. My question is, she's salaried. Her salary never stopped, and the workers' comp are sending her checks every 2 weeks. She's afraid to cash the checks. Is she entitled to that money?
So she's had no loss of any. Why did someone file a workman's comp claim if she was not, she was getting paid?
They I guess her employer automatically did it, and she's getting these checks, and she said, honey, I'm afraid to cash them. And I said, let me see. I'll try to find out.
Well, no
loss of income.
Yeah. I'm going to have to confess that my guess would be that she's not entitled to that money. However, I do not do workman's comp law, and I don't know if there's any special benefit she's entitled to. But I do have a good resource outside the firm that does nothing but workman's comp that I would be glad to, if you send me an email, I would be glad to forward, with your permission, to this person, and then he can verify, to give you a little peace of mind, he can verify the answer. So why don't we do that? Yeah, he does. I send all of my workman comp legal matters to this one attorney. He's outside the firm. You send me an email to Joe, Joe.
Hold on, I'm just pulling off. I'm in the car.
Well, just listen to the show. It's real simple, and I'll give it out several times.
Okay, I'm pulled off. Go ahead.
Joe, it's Joe, Joe, at attypip.com. So it's Joe at attypip.com.
Got it. Thank you very much. As soon as I get the office, I'll email you.
All right, very good. Thank you.
Thank you very much.
All right, let's go to Karen in Jacksonville.
Good morning.
Hey, Karen.
Hi. I have a question about an account with an electric company, a co-op that my mother-in-law had. There's only about $500 in that account that we found out about this week, but she died 9 years ago. And at the time, we sent them the death certificate and a copy of the will, and had my husband's other two siblings sign some things. I guess we didn't realize at the time that we could get a settlement. And what has happened is they have periodically sent a check from that account. The check is made out in my mother-in-law's name with my husband and our home address. So the checks have been cashed, and we didn't get one last year, but we got one recently, which brought this to the fore again. So the question is, they want a copy of the will and a death certificate again, and we cannot find a copy of the will. We do have the death certificate. So,
well, the will at death should have been filed with the county probate court. Do you think, and they might have taken the original and filed it, and it still would be available for you to get?
Okay, well, I did check online with Duval County and around the death, her date of death, and I couldn't find her name, the death certificate listed or anything. But I guess I could, call would it be the clerk of the court? I guess
you could call the clerk of the court, give the name, the name on the death certificate and the date of death, and they can tell you whether the will's been filed there.
Okay, if the will has not been filed, what can we do?
How much money are we talking about here?
It's about $500. So it's not a lot of money, but my husband would like to take care of it, before something happens to him. So we're kind of at a loss if we. Yeah,
is any more money going to be coming?
Yes, they like I said, they do send checks periodically. I don't know if I guess it's once a year. And this year it was about $55. So it's not a lot of money, but...
Yeah, and what's been done to prior checks?
I'm sorry?
What has been done with the prior checks?
My husband has signed them and deposited them, and they have gone through.
And is there one account with still her name on it?
No.
Okay, so the money's been cashed. It's not still all setting into an account.
No. No, it's just we just deposited the check in our checking account, and like I said, it's gone through. I don't know if they would be able to put my husband's name on it or not. But anyway, we would just like to settle it. And you gave me an idea about calling the clerk of the court.
That would be certainly be the easiest answer. If the will is supposed to have been filed within 10 days after death, there's no real penalty if you don't make the 10-day requirement. But if it's been filed, you can get a certified copy from the court.
Okay.
If it's not, if you're stuck with, since it's her name on the check, you might be forced to do some type of simplified probate proceeding, to get the check, which might not make sense because of the small amount of money, because the probate fees would be more than the cost of the... Why don't you do that? Why don't you just check the court and see if it was filed? Hopefully that's the answer. That'll be a simple answer. If that's all they require is a copy of the will, that would probably be unusual too, because then they want some other type proceeding done. But go ahead and see if the court has it and go from there, I guess.
Okay. Well, we'll do that. I appreciate your help. Thank you.
All right, no problem. Thank you.
Bye.
Let's go to Harvey in Hernando Beach.
Yeah, that's Fernandina Beach, but anyway.
Oh, Fernandina Beach, okay.
Yeah, I was just wondering, I've lived in Florida. I lived in Georgia before, and I've lived in Florida for about 5 years. And I don't have a will, but I have most of my assets in both my wife and my name. And I understand that in Florida you don't really need a will. If you, title everything in both names, it just automatically passes to the other spouse. Is that right?
Well, what if you both die at the same time?
Well, then it would be a problem, but not ours.
And what if one of you become incompetent, have to go in a nursing home, then the other one dies, and it's all owned by the nursing home spouse who now can't do anything? So I don't know. So the answer to your question is I think everyone needs a will. And a lot of people don't want to go through probate upon the second death, would do a trust. And it's true where everything goes to the survivor if one of you died, if you own everything jointly. But, so estate planning is dealing with incapacity and death. And there's no reason in my mind to put this off to wait till one of you die or become incapacitated. Just get it done and get it over with and check it off your list and have a little more peace of mind that things have been taken care of.
So you're saying the best thing to do is have a trust?
Have a will? A will or a trust, yes, sir. That's what most of my clients do, trust to avoid probate. I can't say 100% of my clients do trust, but, high, over 90% of my clients do trust to avoid probate. Trust is just a fancy will, basically.
Right, but if you don't have a trust, then it has to go through probate.
If there's the definition of probate would be an asset that's in a deceased person's name. So with no beneficiary, no co-owner, or not in a trust, that now it's in just a deceased person's name, nobody's going to be able to deal with it without a court order, basically, which is probate.
Right. And then if it's in both names, it just automatically passes to the other.
Upon the death of the first one, if it's joint names, it goes to the survivor. True.
With no probate.
With no probate. I before this virus thing, I used to do a lot of seminars, and that would be a very common question, which you've asked me. And I kind of have a little fun with the question because I say the husband's always the one that asks this question because the husband thinks he's going to die first, and then he will never have to fool with estate planning. And my response is, that's just unfair to the wife in this case, and that could go either way. And I'm not trying to be a sexist or anything by the comments, but if the gentleman is the husband is the one who handles most of the finances and most writes the checks, and sometimes it's the wife. But let's say if the primary one that handles the finances die first, the other one is kind of lost at what to do, and why make their job even harder when you can get your estate planning all done and have it all finished, so when one of you die, the survivor doesn't have to worry about it. There's a year or two of not being able to deal with proper thinking and not being able to deal with things as well when you lose a long-term marriage, particularly when you lose somebody. So it's better to... I think
what you're telling me is if you have a trust, you don't need a will.
That's not true. When you have a trust, you have what's called a pour-over will that goes with it.
I see.
So it's a will that kind of catches the loose ends. If you had The example there I give is if you had 5 bank accounts and had a living trust and you only put 4 of them in the name of the trust but forgot one, the pour-over will leaves it to the trust to take care of it.
Okay. All right. Well, thanks a lot.
Yeah, and just to let our Jackson, we've had 4 or 5 calls from Jacksonville this morning. So I do have a Jacksonville office. I do come there on a regular basis. The office is in Ponte Vedra. Most of our services can be done very quickly on a turnaround. So meet with you, 1 week. The papers can be, sent, drafts are out the next week very quickly, and it's not a long, drawn-out process. So thank you so much. All right, let's go to Deborah in Largo.
Hi, this is Deb. My question is, my father passed away 5 years ago, and I found out by a creditor wanting to confirm the date of his death. So it was a bit of a shock. But my mother just passed away, and she had a trust, and she did everything right. But now we're starting to get calls about my dad. Are you the people? Do you own his house? Can you sell it? And we don't really know anything and don't really know where to go to find out.
So you're saying there's still assets in your dad's name?
Well, we're not sure. What I just took over my mom's house, so we went onto the property deeds website, and the house is still in his name, but it says, his name with the word estate after it. So we know they know he's gone, but we don't know, and nobody has claimed the homestead for 5 years. We don't know if it still says estate, so we don't know, does somebody else own it? And when the person talked to my brother about, are you the one that can sell the house? Because we see you as the closest living survivor. Yeah. He says, well, what about his wife? And they're like, he had a wife? So we're not quite sure what's happening with the house. And, we don't know, it doesn't say it's in foreclosure or anything. So is somebody paying the mortgage, or it's just sitting there? Are we going to get a bill one day saying it is our house? So we're not quite sure where to go to find out what's happened with the house.
All right, so your mother just died. Was she married to your father at the time?
No, they've been divorced for a long time. It's just that I don't know if because of her passing, it stirred up people looking up the last name fast, and they're putting out feelers about my dad.
So she didn't live there?
No.
All right, so here's what I think. So the house is in your dad's name. He died. The county knows somehow that he died, so they say it's owned by his estate. Now, who would be entitled to your dad's estate if he did not have a will, and if no one's filed a will within 5 days, or 5 years, let's presume that he didn't have one. So then, by statute, was he married at the time he died? You don't know, do you?
No, he was married, yes, but we do know that her name's not on any of the loan paperwork.
Yeah, but as a spouse, is she still
but
living?
We're not sure if we don't know.
You don't know if she's still living?
No, because we were estranged for about 5 years before he died.
Okay, so let's assume, I have to make too many assumptions here, but I'm trying to just give you a broad answer that could cover many areas. So if he died and he was married at the time of his death, his spouse would have an automatic spousal right to live there for life. And she could have had a right to sell the house, maybe not 5 years ago, but now there's a spousal right to live in the house for life or sell the house and take half the proceeds. So if she was living, have you driven by the house? Does anybody look like they live there?
Well, my brother drove by a couple months ago, and there was a light on, but that was about it. There weren't any cars or anything. We just can't figure out why somebody wouldn't even, use it as a homestead.
Well, his wife, if he had a wife, his wife could be living there and have the right to do so for life. The wife could also have the right, because she has a homestead right to live there, she could rent the property out, and keep the rental proceeds, and then it would not be her homestead because she wasn't living there. I mean, they're all kind of alternatives.
Okay.
You could hire an attorney to start a probate proceeding dealing with the house, and then just kind of shake the bushes a little bit and see what happens.
I think the part of it is that we're afraid to shake the bush a little bit because we don't want it to come back and say no one's paid on the house for 5 years and now it's yours, and all of a sudden we're paying all this back stuff.
Yeah, but the children will not be personally liable for any debts of the estate.
Oh, okay. I think we thought that we would have been.
No, you only the estate is only the debts can only be applied against the estate and the money of the estate, not the children individually.
Now, wouldn't the people who are inquiring if we can sell it, and wouldn't they have known he would have a wife?
No, she didn't apply for the homestead.
Okay. All right. Well, you're definitely unfogging a lot of things, so thank you.
All right, my pleasure. If you need any more help, we have our main office there is in Largo, so I'd be glad to help you.
Okay, thank you very much.
Thank you. Hey, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. Hey, we're open for another 20 minutes or so, 25 minutes. You have a toll-free number. You can call the show. It's 1-800. It's 877 943-9673, 877-943-9673. Mercy. Let's go to Mercy in Kissimmee.
Yes, good morning.
Mercy me. What can I do for you?
Yeah, good morning. I want to find out, do you have an office down in Orlando here, in Kissimmee?
I have an office in Davenport, which is exit 55. Exit 55 off of I-4. We do, if you need to, are you in actual downtown Orlando?
No, I was in Kissimmee.
You're where?
Kissimmee.
Kissimmee. Yeah, I have a lot of clients from some Solavita, which is in Kissimmee, come to my Davenport office.
Yeah. Okay.
What kind of legal matter do you have?
I'm married to someone for 21 years. I have no bank accounts. I have no life insurance. I have nothing at all. And he said to the person, it's time for me to go because I'm 50 here, no house, no money, no children, no life insurance, just nothing, zero. So my question to you, what am I entitled to after 21 years of marriage? Because I keep asking, I don't want to go to court.
Well, after 17 years, the general rule would be you'd be entitled to half of the assets of the estate. You didn't have a premarital agreement or anything, right?
No.
Yeah. So generally, half of the value of the estate is a general answer. After 17 years, there are certain guidelines for under 7, between 7 and 17, and over 17 is usually half of the estate.
Yes, but on the other hand, the reason I'm asking, if the person should be referring to that something.
Hey, Mercy, let me say this: the connection we have is horrible. So what I'd prefer you to do is just call me off the air to where I can talk, because it's just a horrible connection. I'm sure most people are not being able to understand what you're saying. I can, but just listen to the show and you'll have my phone number, email address, and give me a call and I'd be glad to talk to you off the air. It's just horrible radio when the connection's that bad. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen. You have a toll-free number. Phone lines are open. 877-943-9673. Phone lines are open at 877-943-9673. If I can help you in any way, all you have to do is to dial the number. We do have open phone lines right now. I'd be more than glad to help you with your legal situation. And it might be just a real simple answer, something you've been worried about that doesn't really need to worry. You might have a simple answer that can give you peace of mind, and that's what the show's all about. Just why worry? Why think about it? Why try to do your own research and kind of misapply the information and still be more worried after you think you found the answer? Hey, I'd be more than glad to share my experience and legal knowledge with you. All you have to do is to call and ask the question. 877-943-9673. That's 877-943-9673. Phone lines are open. I started the show by giving you a little scenario of a question we came to in front of me this week. And the question was, the gentleman came in and he wanted to know if he could split his ashes. He wanted to be cremated upon death, and he wanted to split the ashes. He wanted half of the ashes to go in with his first spouse and half to go in with the second spouse upon death. So can you split ashes? Well, I can tell you I've had a few cases along the way where the Catholic religion would oppose that. The Catholic religion would oppose splitting the ashes. And I had one case tied up for, 6 to 8 months, I guess, just trying to deal with the issues on splitting ashes, believe it or not. So this gentleman comes into this week, and it hadn't been an issue lately with any clients, but he comes in now, and the funeral home had given him these durable power of attorney type of documents to deal with the remains after death. Well, the problem in Florida, there is no power of attorney that's valid after death. And I wasn't aware of any special power of attorney to deal with remains after death. So I called several attorneys just to verify my thinking on this, and they all agreed there was no power of attorney to deal with remains after death. So some states do now. That's the one of the problems in doing legal research. Some you find something where one state says okay and another state says no. So we figured out the answer that I finally gave the gentleman was, well, the only way that this could possibly work is to put the instructions in your will and let the personal representative who's appointed by the court in the will administer your ashes according to your wishes. All right, let's go to Doris in Lake Wales. Hey, Doris.
Hi. I have a small question. I have all my affairs set up very well for my family when I pass, but there's one thing that I have 2 vehicles, and the title is in my name only, and I'm wondering, is that a problem then for them to change the title? Is that a big thing, or is that a small thing?
No, I tell you, automobiles are one of the easier things to deal with in an estate. There's generally no probate. Generally, the DMV has a form where the personal representative you've nominated in your will can go in there. A lot of times they'll let the personal representative just transfer the cars. And sometimes they get the personal representative to give a power of attorney to the other heirs, your other children, let's say, to be able to deal with the cars. So generally, automobiles are not that difficult to deal with in estates.
Okay. That was my question. Some people say, oh, you should have someone else's name on, and I say, oh, no.
No, that would make them liable if you had an accident, so that's not good.
Yes, and me liable too, or somehow, yeah. Okay, thank you so much.
All right, thanks for calling.
Bye.
Let's go to Amy in Ruskin.
Hello. Yeah,
hey.
I have a question here that, my friend asking me to talk to you and see. She have a son, and look like she put the power of attorney to him. But then he said she said that he looked like wild and he looked like immature, and she is scared that he's to the wrong person.
Yeah, she should revoke. She should revoke that power of attorney and give it to someone else if that's the case.
Yeah. Then she called the attorney that put her son in the power of attorney. She said that take his name out. Okay, and then look like the attorney say that you have to have another person to replace before he take his name out or something. Is that correct? And is that what you do with that?
You need to revoke one power of attorney and have another one drafted, naming who she wants to name.
Well, how do you revoke it?
You sign a document of revocation of the power of attorney.
Now say it again.
You sign a revocation document revoking the prior power of attorney. So it's a document.
No, she didn't know anything, but she didn't do anything yet. But she determined to take his name out.
Well, ma'am, okay. I'm gonna give the answer. Then I'm gonna go to my next call here. The answer is get an attorney to do a revocation of power of attorney document. So, I hope that helps. Let's go to John in Sarasota.
Good morning, Joe. I had a question. I have a business that I lease a unit in my name and in the S Corporation's name jointly. And I'm wondering what's the best way to protect my personal assets, in the case that we defaulted on a lease or something like that.
Well, okay, is the lease in the business name solely?
The business name and my name, both.
Okay, so you have personal liability because it's your name. You're not going to get rid of that personal liability unless you can get a lease just in the business name.
Okay, so there's without modifying the lease, there's no way I could move assets in such a way that would protect me in the event of default.
Yeah, no, even if you could assign the lease, you don't escape the personal liability because your name's on the lease. And your lease might even have language in there that they require, if you're going to sign it, for the landlord to approve the assignment. Because you couldn't assign it to the poorest person in your family, and they couldn't pay it, and to escape liability yourself.
Sure. Okay. Well, thanks for your help. I appreciate it.
All right. Well, thanks for calling. All right, you're listening to Ask an Attorney, all about Florida law. We have about a little less than around 10 minutes left in the show. Maybe a little bit more than 10, or maybe a little bit less than 10, actually. If you have a question, though, you have a toll-free number, 877-943-9673. That's 877-943-9673. So for 14 weeks, every other week, we did so we have 7 Zoom seminars. We have all those on tape and everything that we can share with you. One of them, the last caller might want to look at, is on asset protection. We had another one on concealed weapons, stand your ground, gun law in general. We had another Zoom seminar on trust and estate planning. We had one on probate. We had one on Medicaid. We had one on family law. So we had 7 Zoom seminars. We made a little YouTube channel, but we also can send you a link to any one or all of those if you'd like to learn a little bit more about any of those subjects I just mentioned. And to get the link, just send me an email to Joe, Joe, at attypip.com. That's Joe at attypip.com. Let's go to Susan in Osprey.
Hi.
Hey, Susan.
Yes, I have a quick question. My husband and I own a home in New York as well in Osprey, Florida. I'd like to pay off the house in Osprey, Florida, and just put it in my name. We already have a revocable trust. Will that house in Osprey, Florida, automatically be part of that trust?
Well, there's nothing automatic. Is Florida your homestead?
No, we're not homestead in Florida, no. But if I put it in my name, I hope to, me personally.
Is the trust
homestead?
Is it a joint? Is the trust a joint trust?
Yes, it's a joint trust.
So you want to take it out of the joint trust. As long as it's not a homestead, the answer is you can take it out of both names or both names as trustees and create your own trust. If you,
I would have to create a new trust. And if I homestead, would I have to create a separate trust?
Well, you have a joint trust, so if you want to own the property individually, you would need to have your separate trust.
Okay, got it.
A joint trust is for joint assets, and an individual trust is for individual assets. And as long as it's not a Florida homestead, you can put it into your individual trust.
And if it's a Florida homestead, it doesn't make any difference. I would still have to put it into a separate trust.
Well, then if you made it your homestead first, then there are spousal rights concerning homestead. So if I were going to do this, I would do it while it's not your homestead. Because a spouse, even if you have it in an individual trust and were able to do so, and you did it before you became a Florida resident, your spouse has a right to live in the home for life and or sell it and take half of the proceeds. That's just a standard. You can get the right waived with a pre or in your case, a post-marital agreement.
Oh, okay. So
it gets a little bit more difficulty.
Before homestead? Yeah. It sounds like it.
Well, it gets more complicated if it's homestead. It would be fairly simple if it wasn't homestead. So what I was advising you to do is whatever you do it before you make it your homestead, and you'll be fine.
Oh, okay. Okay, I see. And then I can go and make it my homestead after.
After, yeah. But then your spouse is still going to have a right to live there for life. Maybe you want to do that anyway, or sell it and take half the proceeds, unless it's waived.
Okay. Perfect. Thank you so much.
Hey, what's Osprey best known for?
I don't know. I mean, I might know, but it's not coming to my head right now.
Yeah, they're famous.
Besides the birds?
Yeah, well, Osprey is famous for those drinking glasses that are, what are they called?
Oh, really?
Tumblers, or I think.
Oh, Tervis tumblers.
Yeah, Tervis.
Okay, got it. That's okay, you're talking about
to me, when I see Osprey, that's what I think about.
You think of the
Tervis tumblers? Yeah, okay. I think that's what they're best known for. All right, but that's probably not true, but that's just what I think. All right, thanks.
That's what you think.
All right.
Okay, thank you.
Bye-bye. Let's go to Victor in Tampa.
Yes. I'm going to reverse the mortgage. Reverse mortgage,
okay.
And on closing, can I have an attorney with me to look at it? Because they normally would do a title company, right?
Sure. Well, sure. You can have an attorney help you with closing if you sold your house and it had a reverse mortgage on it. A reverse mortgage is just a lien. So the reverse mortgage would have to be paid off, but any equity that's in the property would be yours to keep.
Yeah, no, I haven't done it. I'm planning to do the reverse mortgage, but I'm 77 years old, and my son stay with me. My son is living with me, and of course I can't put his name on one because I'm the only one.
Mm-hmm.
I haven't closed the deal yet, but
yeah, well, it's no problem. You can. Your question is, can you have an attorney? Of course, you can have an attorney help you with the reverse mortgage.
I'm closing, right?
Yes, sir.
Okay, so because I used Moses before with my trust.
Yeah.
You know Attorney Moses.
Yeah, he works for me. Yes, sir. I know him.
So I can call him. He does that.
He can. You can just call our office. I can. If Dennis can't help you, I have an attorney that specializes more in real estate. Dennis is mainly in estate. Does mainly estate planning, but the firm can definitely help you.
Okay.
All right, Victor.
All right, thank you, sir.
Thank you. All right, so you've been listening to Ask an Attorney all about Florida law. We're here every week just to answer your legal questions. Also, if you're listening in the Tampa Bay area on 570, 910, they rebroadcast this show at 5 o'clock on Sundays on those two channels. We also, if you want to know more about the radio shows, we have other radio shows as well. You could go to attypip.com/radio. And we have a little website there, a little part of our website. You could just do the /radio and get right to it. attypip.com is our website. You put in there /radio. We have other radio shows we do on other radio stations. You can get a little blurb there. Also, we have a YouTube channel with probably over 100 videos of different shows and television shows and radio shows and seminars that we've taped there. Just go to Joseph Pippen, Law Offices of Joseph Pippen, to find that. We're also broadcast live on WeBeam TV. There's a host of channels there. If you have an iPhone, we have an Ask an Attorney app. There's many previous shows there. Of course, we're on Facebook and LinkedIn. If you want to connect with us, just please send a link. So thank you so much. I hope you have a great rest of the Thanksgiving weekend. Thank you for listening to Ask an Attorney all about Florida law. And again, if you want to call our office, you have a toll-free number, 1-800-226-3529. That's 1-800-226-3529. Hope you have a great, safe rest of the holiday weekend. And remember, ask an attorney. If you get to ask a legal question, you probably shouldn't try to answer it. Tell them about the show. Ask an attorney all about Florida law. Okay, you have a great weekend. So long and be safe.